We are pleased to welcome Judge Larry Thorne on this Wednesday, as we do each and every week for our Ask the Judge segment.
Thank you. It's
Always
great
a
to
pleasure
be
have you
here. But I just want to say something about what Patrick said. He said that summer starts next week.
No, this Saturday.
Well, okay, this Saturday. Well, I think it started several days ago.
Maybe a few weeks ago.
Yeah,
even.
that's what I'm thinking. It's hot.
Mother Nature has no respect for the calendar
Absolutely
here
not.
in Southeast Texas. All right, we'll get to our questions now. The first from a woman who says she's owned her own home for 23 years, but she got married 2 years ago. They've been living together. She wants to know, if they were to divorce, could her husband take her home or any portion of its value?
You know, I'm wondering why she's concerned about that issue at this point. This really doesn't bode well.
2 years, it's
Yeah,
rough.
yeah, but the answer is no. That's her separate property, Jackie. And the court, in a divorce case, cannot divest somebody by law of their separate property. If they made some improvements to the house, he could ask for reimbursement to the community. Say they added a garage or a room or whatever, a swimming pool. He could ask for reimbursement to the community estate, but it's not dollar for dollar. It's the increase in value. So they'd have to have the home appraised. So they spent 50, but the pool only added maybe 10,000 worth of value. Then each one of them would receive half of that, 5,000 back to the community. So,
right.
But no, can't divest her of her separate
Good
property.
girl.
Home. Yeah, she's
right.
good.
Okay, our next question. Can a majority of beneficiaries elect to dissolve a trust set up in Texas as a living trust if the grantor passed away a year ago?
I love this question. This is a great question. And just a little explanation real quick is in Texas you can avoid probate if you have a living trust. And that's where you take your house and you, the beneficiaries are, say, your kids, and then you pass away, and then you create what's called a flow-over will before you pass away. What happens is the will would then put everything in the trust, and then everything is divided in the trust, and then the trust is over with.
Okay.
The general answer to this question is no, because when the person dies, the trust is then irrevocable. But you have to first look at the language of the trust to see what it says. If it says you can do this, then fine. If it's silent, then it becomes irrevocable at the time of death. And hopefully they can avoid probate if they had a flow-over will, which would be the reason to create the living trust.
So they probably need an attorney to take a look at this, to look at the
because I'm sure I confused everybody.
Right. All right. Okay, our final question, Judge. I like this question.
Yeah.
My ex-wife remarried and is now divorcing. Can she legally take my last name back?
Man,
Take back my last name?
This is a feud that obviously never ended. I mean, we're talking a marriage later, several marriages later, I don't know. Folks, just let it go. Just let it go. The answer is yes, she can take that name back.
You can really name yourself whatever you want, really.
Yeah, pretty much. But hey, there's a positive side to this. I want this gentleman
What is the positive side?
The positive side is, hey, she obviously likes you better than she likes her current newly divorced husband. So, hey, you're the favorite because she's taking back your name. She doesn't want his.
I don't know if that's going to matter.
You don't
to
think
this
that
guy,
works?
But
Oh.
we appreciate your effort there.
Sure, sure.
All right. If you have questions for Judge Thorne, you can send them to 12news at kbmt12.com. If you are looking for an attorney, you need some assistance, contact the Jefferson County Referral Service at 409-835-8438. We'll see you next week.
All right, great. Thank you.
All right. We'll be right back after this break.